court. This is another episode of the Canton cover-up series, Commonwealth versus Karen Reed, and this is episode 115, Liza Little Clarifies Statement on AARCA filings. So this is going to be a rather quick episode. We have a couple filings that I wanted to go over with you really quickly. We're still catching up. They're still not even catching up. Filings are just coming out daily, and it's hard to stay on top of them. But we are trying, and we are, whoops, we are doing the best we can. We're pretty caught up, but there's plenty of filings that are still pending, and they're still arguing. So, all right, let's get started here. Please hit that like button. This first filing that we're going to go over is a clarification regarding a statement in defendant Karen Reed's opposition to the Commonwealth's motion to exclude employees of AARCA. So that was how the Commonwealth titled their motion. So now every single motion that references that motion has to say to exclude. But anyways. All right, so now comes the defendant, Karen Reed, and files the instant supplemental affidavit of Elizabeth Little clarifying the following statement, which was included in defendant's opposition to Commonwealth's motion to exclude employees of AARCA, which I prepared and filed. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. To be clear, the defense did not hire, retain, or pay AARCA to engage in the reconstruction, analysis, and/or testing that was performed by AARCA in connection with this case. The defense did, however, reimburse AARCA for the following time and expenses after trial and after the defense received the AARCA invoice dated July 12, 2024, which was provided to the Commonwealth in reciprocal discovery on February 20th, 2025, prior to the filing of the opposition, travel expenses and time associated with traveling to Norfolk Superior Court for the voir dire and trial in this matter, a total of 0.75 hours, less than an hour, in calls with the defense regarding coordinating attendance at the voir dire and trial. Because remember, they had to come in twice. They had to do the voir dire, and then they had to come back in and testify. And discussion regarding experts' background. So they had to talk to them a little bit about their background just to prep slightly, which they were allowed to do. It was okay that they prepped slightly. They didn't get into the details or discussion of their findings, so that was okay. And 3, time spent testifying in court and the expert's internal preparation for voir dire and trial testimony. So not only the time that the experts traveled, prepped, discussed, had phone calls with attorneys, all of that. And also they had to prepare for their voir dire. They had to prepare for their testimony. They had to re-review things. I'm sure it took time. So they charged that time back. And that is what the defense was paying for. It was not for the reconstruction or anything of that nature. It was their time, which everybody gets paid for their time, whether you like it or not. So I don't know. Judge Canoni is still, she's not, I don't think she's going to take kindly to this, but I think it's good that Liza clarified this statement and made sure that Judge Canoni knows when I said this, I meant this. And that is what we were all referring to whenever we say we did not hire or pay for AARCA. The defense did not know what, if any, little throwback to Lolly, what, if any, expenses they would be responsible for covering until after trial in this matter concluded and they received instruction and guidance from the United States Attorney's Office. So it wasn't until after trial they received a bill. The bill came. They went, "What the heck is this?" They went to the U.S. Attorney's Office and they're like, "Do we pay this? Is this something we should pay? Can we pay it? We don't even know how this works." And the U.S. Attorney was like, "Yes, you can pay that." So that was paid after trial. They didn't even know they were paying that much money or that amount. They didn't even know what they were paying, if anything. All right, so supplemental affidavit of Elizabeth Little, Esquire. I, Elizabeth Little, do hereby depose and state that the following is true to the best of my knowledge and belief. I represent defendant Karen Reed pro hoc vice. The facts set forth in the clarification regarding defendant Karen Reed's opposition to the Commonwealth's motion for to exclude employees of AARCA filed herein are true and correct to the best of my knowledge, information, and belief. The statement called into question by Special Prosecuting Attorney Hank Brennan at the last hearing was poorly worded and should be reflected more specifically that the defense did not hire, retain, or pay ARCA to engage in the reconstruction, analysis, and or testing that was performed. So again, she is clarifying that statement one more time. Whoa. Yeah, that was me. That wasn't the dog. He slipped. All right, so that was they did not pay ARCA to engage in the reconstruction analysis or testing that was performed by ARCA in connection with this case. She says, I personally edited and was responsible for filing the opposition to the Commonwealth's motion for to exclude employees of ARCA. The opposition, which included that phraseology, was drafted by a law clerk and no other attorneys worked on the opposition. So she personally edited it. There was a law clerk who wrote it. She is clarifying it. So there's that. So it's good to have it on the record, especially when you have a judge who doesn't play by the rules. It's good to have it on the record that Liza meant this when she said that. So, very good. All right, we have two quick Commonwealth motions because this is a shorter episode. It would have only been a few minutes. These are we're going to read these Commonwealth motions. So, first of all, by the way, the defense has already filed their certificate of discovery, which means they should have, which means they certify on the record in court that they have turned over every piece of discovery. Yet, we are still getting piecemeal everything. Well, why is this happening? Why are we still getting discovery turned over? They've already certified discovery, yet here is another notice of discovery. You can't make this up, guys. Comes now the Commonwealth in the above captioned matter and indicates that of this date, the following discovery material has been provided to the defendant through defense counsel. Copy. A copy of the MSP report, so Massachusetts State Police Report number 108, dated 2/19/25, 32 pages, including attachments. Copy of Trooper Lieutenant Tully's notes to MSP report number 108, 1 page. Interesting that they're still getting police reports on what? On what could they possibly be getting police reports on? For crying out loud. All right, so copy of Dr. Crosby's addendum to report. So he's providing an addendum to his already awful report, which didn't provide any methodology on how he got to dog bite conclusions. Copy of transcript of unredacted Gretchen Voss interview on 6/20/23, 257 pages, including Word index, which was previously provided to defense by email on 2/24/25. So all of Gretchen Voss's notes, who I think she's with like Boston Magazine or something, 257 pages of notes? How is Karen Reed even responsible for that if this woman writes that many pages of notes? How is If this woman writes something, that doesn't make it fact just because it's in her notes. All right. Anyways, copy of transcript of unredacted Gretchen Voss interview, which is 87 pages long, including a word index, which was previously provided to the defense on 2/24/25. So all this stuff is still coming in. This is crazy. Copy of email of special or to a copy of an email to Special Prosecutor Hank Brennan, 2 pages. Copy of email to Hank Brennan, 18 pages. Copy of email to Hank Brennan, 2 pages. Copy of email to Hank Brennan, 8 pages. Is this just like the trolls, the anti Karen Reed trolls are like, oh, let's email Hank Brennan with something that we think is, all the lies that they come up with and say, oh, Karen's guilty for whatever reason. She's crazy. And who knows, whatever complaints they have. So are these trolls just writing Hank Brennan and Hank Brennan, because it's about the case, has to turn it over or what? What do you guys think? This is weird. Another copy of email to Hank Brennan, 1 page, 1 page, 3 pages. So these are all emails that have come in through the month of December. I'm sorry, not December. The month of February. I don't know why I got December. All right. Where else are we? All right. So copy of voicemails to Special Prosecutor Hank Brennan, 2 audio files. An MSP report, number 109, 3 pages. Another report from MSP dated 2/28. Both of these are dated 2/28. This is a 1 pager. Copy of Canton Police Department report dated 2/27/25, 1 page. Copy of reproduced Bates stamp NDAO, and then it's got a item number or whatever that is, which was previously provided on 1/30/25, subject to a protective order. So there you have it. There's still a bunch of discovery being turned over. Some of it might just be troll emails. Makes no sense, but cool. All right. Next, we've got the Commonwealth's motion to unseal FTR audio from March 4th, 2024. So for the hearing that took place Tuesday, March 4th of this week, the Commonwealth wants that audio. So the Commonwealth moves this honorable court unseal portions of the FTR audio from a motion hearing occurring on March 4th, 2025. During the motion hearing, counsels and the court engaged in lengthy sidebar conversations that were subsequently sealed by the court. The Commonwealth moves that this court unseal the recording for counsels of record only. So it's not going to be unsealed for the public, just for the attorneys. The Commonwealth intends to obtain a complete written transcript from the motion hearing. So they want the transcript, they want the audio of the sidebars that took place today. So that is interesting. I wonder, I really, to be a fly on the wall because I would be right over there listening in on their conversations, on their sidebars. I wonder if they get heated. Like, I really want to know, like, is Hank such an ass, the same ass that he is in open court when he's on the sidebars, or is that just for show? I just want to know, like, how are their demeanors? It's got to be so awkward and strange to be around someone that is so unappealing, and the fact that he is just outright lying about, oh, that's the other thing. I believe this is a lie. He said in open court on the record that he spoke with the Attorney General, Massachusetts, and they told him that the federal investigation is over. Since when do they announce that federal investigations are over? Since when do they announce that people who were targets of the investigation will no longer be targets, they don't announce that. I absolutely think that he's lying. Chief Rafferty came out with a announcement too, saying that there was no one found guilty of anything and the federal investigation's over. The Canton Police Department put out an announcement. So that just goes to show how bizarre and odd this is that the same day that Hank Brennan makes that announcement, the chief of police also makes the announcement for Canton Police Department. And it's also very bizarre that in January, the end of January, there was a letter from the U.S. attorney stating that the federal investigation is ongoing. I believe the date was January 20th or something like that. So between January 20th and the end of February, somehow the investigation just ended, even though they were told in January it was still ongoing. And then somehow the AG just picks up the phone, calls Hank all of a sudden and says, "Oh, by the way, investigation's over." But when they told them that it was still ongoing, they received a letter, both sides. So why would the AG announce to Hank Brennan ex parte, meaning that the other, the defense was not in that conversation? Why would they announce it there? It doesn't make sense. I don't think it's true. I really would love if the feds would make an announcement and say that is or isn't true, but they can't because they don't make announcements like that. So the feds are kind of stuck with their silence, and the Commonwealth is just totally, with no repercussions, allowed to make people believe that the federal investigation is over. This is insane to me. This is what's happening in Norfolk County. I have been on my X page. If you're not on X, I encourage it if you follow these cases because you get so much information from all over, really smart, well informed individuals on these cases that are talking about it. And you get evidence, that people provide receipts on X. And it's a, despite the vitriol that does happen on social media anywhere, I think X is a good place to get your information about these cases and to get court documents and things like that. So I never used to be an X person, and now I'm addicted to it only because of these cases and trying to be a part of it. But anyways, my point was on X, I have been posting things like impeach Judge Cannoni and disbar Hank Brennan. So these are things that I want you guys to also think about in your social media posts. If you see my posts, please share them, like them, get the message out that we need to have some accountability in Norfolk County and not just there, but in our judicial system entirely. So that's all I have for you. Thank you guys so much for watching. Please hit the like button on your way out. Make sure you are subscribed as we keep updates on this case as frequently as we need to, even if that's multiple videos a day, which just happens. It happened today. So let me know what you guys think in the comments below about these filings and the Karen Reed case and the federal investigation being over. Do you think it's over? I don't. Let me know in the comments below, and I will see you guys in the next one. Take care. Bye now.